Good evening, everyone, and welcome. Thank you for joining us this evening for our National Security and Civil Liberties webinar. I'm Nikki Mamars today. I'm the Legal Education Director of the Iranian American Bar Association's DC chapter, and I have the pleasure of serving as your moderator this evening. This is our first program since Nowruz, or the Persian New Year, which took place this past Friday. So on that note, I hope everyone is having a good start to the new year, despite everything going on in the world and in Iran specifically. With that said, I want to provide a little bit of background about IABA before we get started. For those of you who may know, IABA's mission is to educate the community about legal issues of interest to Iranian Americans, to protect and advance the rights of Iranian Americans and other minority groups, to promote and foster the achievements of Iranian American legal professionals, and to fundraise for law student scholarships. This year, IABA is putting on a series of legal education webinars and in-person meetup events, so please follow our social media channels to stay engaged. Before we dive into the presentation, I have a few housekeeping remarks to ensure that we have a smooth and productive experience tonight. Please keep your audio muted for the duration of the webinar, and feel free to submit your questions in the chat box, and I will read them throughout the presentation and at the end, where appropriate. And please note that this webinar is being recorded and will be uploaded to our YouTube channel and legal education library for everyone's benefit. I want to emphasize that the information that's being shared tonight is for educational purposes only and does not constitute legal advice. If you should require specific legal advice, we strongly encourage you to consult with a qualified attorney. Additionally, to the extent that any opinions are expressed, those are the views of the speaker and not of IABA DC. And any supplemental materials, such as the video recording, will be shared in IABA DC's Legal Education Library, which you can find on our social media profiles. Now, without further ado, it is my privilege to introduce our distinguished speakers for this evening. Kia Rahnama is a senior associate with Fluid's Litigation and Government Investigations Practice Group. Previously, Kia served as an assistant attorney general in the DC Office of Attorney General's Legal Counsel Division and worked in the Office of the General Counsel at the White House Office of Science and Technology. Kia also served as a judicial clerk at the U.S. Court of Federal Claims. He received his master's degree in international affairs and his law degree from George Washington University. And Kia Hamadanchi is a senior policy counsel at the ACLU. Prior to joining the ACLU, Kia worked at the Peace Street Project and the Congressional Progressive Caucus Center. He also served as an oversight counsel on the House Education and Labor Committee and as a staff member in the U.S. Senate under Senators Tom Harkin and Sherrod Brown. He received his bachelor's and law degrees from the University of Michigan, and he's also the outreach director for IABA DC. So thank you to both Kias, or as I've been calling them, Kia Ha, for joining us this evening. And with all that out of the way, let's get started. There's so much to talk about. So could one of the Kias just tell us a little bit about the principal agencies that oversee national security, just for everyone's kind of priming benefit?
Yeah, so I can start and the other kid can add. Within the national security, there's kind of a broad umbrella of agencies. FBI is a major one. Central Intelligence Agency is another major one. They're not technically allowed to operate inside the United States. The National Security Agency, or NSA, is another one. They primarily do administer statutes like the Foreign Intelligence Surveillance Act. So they're gathering a lot of communications, sometimes of Americans. The office ODNI, or the Office of Director of National Intelligence, is another one. They came about after the 9/11 and kind of serve as kind of the coordinating agency. There's NCTC, or the National Counterterrorism Center. Treasury has a lot of national security implications within kind of some of the financial sanctions laws they do. Of course, there's the Department of Homeland Security, which is kind of a big umbrella agency, which covers things like ICE, the Immigration and Customs Enforcement, CBP, Customs and Border Patrol, USCIS, which is United States Citizenship and Immigration Services. And then I would also say the State Department is also a national security agency that has a major role in a lot of these programs. Nikki, I think you.
Yeah, sorry, I'm muted. First time moderating, so I'll get the hang of it. Thank you, everyone, for your patience. I think you teed up those issues perfectly, Kia, and in particular, you mentioned DHS, and I think something that's been on everyone's mind over the last couple of weeks is, with the federal shutdown, with partial shutdown regarding DHS, and I don't know who has personally been at the airport, having to deal with TSA and ICE, and it's something that's at the top of everybody's mind. So I think people are very anxious to know, what are our rights at the airport or at the border. And there has been a lot of movement on that front. So under the January 2026 Customs and Border Protection Directive, officers can conduct a basic search of your phone without any suspicion. So what exactly should somebody do at the airport or at the border if asked for their passcode or asked to consent to a search of their phone? What should you do practically under those circumstances? And does that answer depend on, what your status is?
So the first thing is well, the ACLU is litigated that this that whether that they are not allowed to search your phone. CBP is currently taking the position that the border at the border they are allowed to search your phone, and so they can seize your phone for up to 15 days. Um, I believe it's 15 days. But if you are a U.S. citizen, you are not required to give them your password. So you're not if they cannot deny you entry from the United States for refusing to unlock your phone. Now, if you're not a U.S. citizen, you don't have that option. They can deny you from entering the country. So I think the biggest thing is two things I would say if you get asked for a border device search is one, if you're a U.S. citizen, do not provide your passcode. Two, ask them for a receipt for your phone. I think that's really important. And the third thing is if you have any privileged information, for instance, for information that's attorney-client privilege, I would make sure um, that it's that's labeled and you tell them that there's attorney-client privilege on that on your device. Um, and honestly, your best bet is if you're something you're worried about is to wipe your phone entirely before you go through the border and then back it up from the cloud once you're finished.
Yeah, that's I think most people don't know about the cloud issue, which is technically neither ICE or TSA officials or Kia correct me are not supposed to technically they don't have the right to look at the stuff that you're holding on the cloud, even if they get access to your phone. At least that's what we believe. We don't know if that's what's happening at the airports or not. But historically, the airports are these weird places in the US where the Supreme Court has said that for domestic arrests, for example, if they pull you over, if law enforcement pulls you over while you're inside of the country, we don't have this distinction between citizen or non-citizen in terms of whether or not a police officer can search your cell phone. But everything is different at the airport. Effectively, citizens have the right to re-enter, which gives them this right to say no to search. But historically, the courts have seen non-citizens arriving at the airport as you're presenting yourself effectively for inspection to enter the country, which limits your right to say no to these searches. So that there's a basic search and there's a forensic search that they could do, and those two things are different. Kia, I don't know how this plays out at the airport, whether or not the officers actually tell you, I want to do a basic search or I want to do a forensic search. But I know that could definitely have an impact on whether or not people want to say yes or no, and how deep those forensic searches are. My understanding is that they can effectively hook your phone to a device that reads everything on the phone if you haven't done your due diligence of encrypting the phone, making sure it's turned off before you go through Customs and Borders protection.
Yeah, I mean, I would say the number one key is do everything you can before you cross the border, which is turn your phone off or have it in Bluetooth mode. Make sure everything on your phone is encrypted. Make sure if you have it in cloud, you're using cloud services that are and encrypted. So it makes it as difficult for them to search your phone if they have access to it. And again, if you're a U.S. citizen, you have no obligation to turn over your passcode and unlock your phone.
And then what about for non-US citizens? So there is the obligation to turn things over. What, besides the obligation to turn things over, are there any more rights that you may have as a non-citizen, or does it depend on, where you're from? If your phone is, based, I see a question from the chat asking if you have greater protections with a Switzerland-based phone, because Switzerland has more stringent data privacy laws. Is there any interplay there? Or is it just kind of US citizen versus not?
So the ACLU would argue that the Fourth Amendment applies to everyone, whether it's a U.S. citizen or non-citizen, and applies at the border. But the CBP that is not the position that CBP takes. And then I think it's important. And then this is still something that is being litigated currently. And for the time being, as a non-U.S. citizen, they can you just don't have the same rights.
So on the note of, rights at the border, something else that I think is something that's evolving and of concern is the collection of biometric data. So DHS has also issued a biometric entry and exit rule, which I think went live in December, which mandates facial and biometric collection for almost all non-citizens. I believe it's voluntary, and U.S. citizens can opt out. Is that true that US citizens can opt out? And does anyone else have a legal right to opt out of facial recognition at the border?
Generally, yes, U.S. citizens are able to opt out. But again, unfortunately, when you're not a U.S. citizen, they don't give you the same options.
And DHS, I believe, retains the biometric data for non-citizens for up to 75 years. So given the geopolitical climate that we're facing today, what are the risks of this data being shared with other federal agencies or maybe even other foreign governments under various intelligence sharing agreements?
Yeah, I mean, and I'll let the other key answer of this, but one of the things we've seen under the Trump administration is a lot of consolidation of databases. And so you've got within DHS and within the government, and this happened a lot when Elon Musk was there, is they're essentially consolidating as many databases as possible. A lot of it's feeding into the immigration enforcement side of things, but it's also we're getting to this point where we're concerned the idea that the government would essentially have dossiers on people based on all the information that they have, and that's a concerning thing. But I'll let Kia add to that.
No, definitely. I think this is the biggest thing happening in the area of national security and civil liberties is that historically, since Watergate, courts have drawn this line between, all of the agencies and departments that Kia mentioned. The courts have drawn a line between the ones that do domestic law enforcement and the ones that take care of foreign intelligence. So CIA and ODNI might be able to surveil you and gather information on you legally as long as that's being done for foreign intelligence purposes and the information that they collect is not used for domestic law enforcement to prosecute you, for example, as a citizen for your conduct. That's been a bright line division rule since the Watergate, but this administration's view is that foreign adversaries' conduct is causing a lot of unrest domestically, so they're viewing really their role in curbing national security threats differently. They don't see that difference between domestic law enforcement and national intelligence gathering as clearly as the other administrations. So it's become more common practice for the agencies that Kia mentioned to share information. I mean, big news this year was, as an example, DHS sharing information about undocumented immigrants with IRS. There's more recent news that the administration might issue something formalizing their understanding that the foreign intelligence agencies can share information with the law enforcement agencies. It raises a lot of risks for civil liberties because FBI and DHS have more limited authority to search and seize information about citizens than ODNI and CIA do. But as those walls start to come down, citizens are a little bit at a higher risk for their conduct to be information that the agencies are holding on their conduct to also be used for law enforcement purposes, in addition to just surveil the country to protect against outside threats.
And just one thing I want to add to that, one of the things we're seeing, and they were seeing this across pretty much every agency in government, is that agencies are buying a lot of data from data brokers that they would otherwise need a warrant to obtain. And so agencies like the FBI, agencies like the IRS, pretty much across the board, they're buying things like web browsing data, they're buying things like cell phone location data. And these are all things that if you wanted to obtain it, you'd need to go get a warrant, but it's because it's for sale on the open market. These agencies have taken the legal position that they can just buy this up, and they're buying up all sorts of data, not just not Americans and non-Americans. And ODNI did a report on this a couple years ago when it said that the government has no overall understanding of what agencies are buying what data and for what purposes. Like we don't even have we have things we've gotten through like FOIA requests and things like that, but no one has a full understanding of what exactly the government's doing with this information, and
Wow.
obviously sharing it with each other without, I think, without a lot of protections.
And one more question I have about the airport before we, airport related and border related issues before we move on. We've seen a sharp rise in both in terms of anecdotal evidence and reporting of Iranian Americans being funneled into secondary inspection when entering at the border, regardless of their citizenship or other status. Is there a legal threshold where routine border questioning like this becomes illegal profiling based on national origin? And is there routes to challenging this conduct?
There's back an ACLU lawsuit on this, specifically on discriminatory questioning of Muslims coming to the United States. So there very much are routes to challenging this, and it is something the ACLU has challenged.
I think it might be easier to ask you what the ACLU is not challenging. So that's really good to know.
Yeah,
Um,
usually this, I mean, one of the I guess new challenges is going to be with ICE's presence at the airport. So TSA does not have, again, to go into what Keo was saying, each of these agencies has delineated authority, and all of their authorities are limited. TSA historically does not have law enforcement authority. If you're misbehaving at the airport and all you're dealing with are TSA officials, they want to put handcuffs on you, they need to actually call the state police or the federal police to come arrest you. ICE does have law enforcement authority. So that's why people are seeing all of these videos of effectively rougher treatment at the airport at the hands of ICE officials. They could behave in a way that TSA officials don't have the authority to do. So it's very much playing out at how they're going to handle um, long detentions at the airport too. From recent news, it seems like they still seem to be wary that of the fact that you can't really hold citizens at the airport for long hours. But usually when those cases end up at the courts, it is very fact dependent. But for due diligence, for people who are taken to secondary inspection at the airport, is just be aware that what you say does matter. Whether or not you're consenting to a search, whether or not you're asking the officers who are holding you for inspection why you're being held, to the extent that you're cooperating. If things go awry, your conduct does matter in terms of determining whether or not they violated the law or not.
Two things I was going to add is I dropped the information for that case in the chat if anyone's curious about it. And then the second thing is in regards to immigration and ICE. The other thing we're seeing is TSA is sharing a lot of data with ICE and with immigration authorities, like the sorts of information that hasn't been shared in the past. And I think the related point of that is I think one of the things we're watching for is kind of increased use of watch listing programs, because those programs are obviously incredibly problematic. I think that people get put on them for all sorts of reasons where they shouldn't be on them. And then once you're on one of those programs, it's very hard to get off. There's not a very good redress process. And it is the sort of thing that the executive branch can do without having to go to like a court or something like that. So that's something that we don't know when it's happening necessarily, but the kind of thing we're keeping an eye out for.
Well, I think what you mentioned about the information sharing between like private data brokers and things like that is a great segue to the next thing I want to talk about, which is, your digital civil liberties, particularly related to social media. The DHS and the State Department have, drastically expanded their social media surveillance protocols when evaluating visa adjudication and domestic status reviews. Uh, I believe under Executive Order 14161 and then further agency directives, social media screening has transitioned from an optional pillar to a mandatory central pillar of visa adjudication and domestic status reviews. The State Department now supposedly frames every single visa adjudication as a national security decision, and social media review is part of that. Do we know how these agencies are coordinating with social media companies to flag problematic accounts or to get access to people's accounts and postings?
So I don't think it's necessarily that they're coordinating, not always with the social media companies. I think they specifically have tools, a lot of which are driven by AI, which are essentially scraping people's social media. And this is like it's kind of like an ever-growing practice, right? It's the sort of thing that continues to grow and it continues to exponentially. And I mean, I think this was not like this was the sort of thing like people talked about, like people talk about Anthropic and AI, domestic surveillance of Americans, like, you know, we never envisioned that these sorts of or I guess actually we didn't think so quickly that these sorts of tools would exist, which kind of allow you to scrape everyone's social media data so quickly. And I think I think two things are right. One, it's happening at a huge scale, but two, it makes tons of mistakes. It's people act like it's 100% reliable. It very much isn't. And then people are having decisions made against them because of things that were these tools found on social media that aren't correct. And it is very much we've seen them targeting people for their speech having regarding Palestine using these tools and kind of making immigration decisions based off that. But I'll turn it over to Kia if he wants to add anything.
No, this is definitely one of those areas where the guidance that's coming out from the agencies is when you read it, it's definitely suspect, and it's you would assume that it is susceptible to legal challenge in terms of moderating the content of people's speech online. It is a tough area to litigate eventually because immigration officials retain so much discretion in denying or accepting um, immigration applications that they could get your social media account, read everything. They don't have to necessarily disclose why they're denying your application. They could read your social media post and disagree with things that you're posting politically, but not necessarily specify that that's why you're being denied, which makes it more difficult to challenge. Immigration applicants are put in this bizarre situation of having to report their own social media accounts. Every immigration application that you submit outside the contents of whether or not you want to disclose everything or not, you effectively attest that you're presenting the US government with a full application and you're disclosing everything. So that raises its own problems where if you list two or three of your social media accounts, but then they scan you online and see you didn't post your LinkedIn and they don't like the stuff that you posted online, they could just deny your application based off on a point of veracity and say, why didn't you disclose this one? So um, it's going to be a very tough area of law to litigate for sure. Some self-auditing I think is probably advised, but I think here I think from what I've heard is that they have tools to also figure out whether or not you've mass cleaned up your social media before disclosing it to USCIS. So that usually puts people in trouble too.
I mean, one thing I'll add is that social media monitoring is not something that's new under the Trump administration. Like it's something that has happened under like a lot of surveillance tools. It's something that's happened under presidents of both parties. I mean, it is true that the way they're using it is more extreme in many ways, but like this sort of stuff did happen under Joe Biden as well.
And if someone just on a practical note, if your Instagram account is private, are they still able to scrub, or is it only for accounts that are public?
As far as I'm aware, I think it'd be much more difficult. I mean, that sort of technical expertise is not. I'm not quite sure, but it's also possible. I mean, and we talk about things like administrative subpoenas.
Mm,
There have been cases where they've gone to the social media companies and gave them an administrative subpoena for information from them. So I
right.
mean, like we don't know that kind of stuff. That kind of stuff could be happening as well.
Yeah. We have a question from the chat. To what extent is federal law enforcement allowed to spy on citizens and non-citizens domestically using AI tools?
Okay, if you want to go first, but
I mean, if the background is litigation, the courts are usually very, very deferential to the executive agency's foreign intelligence power. Now, this has always been the case against the background of the foreign intelligence agencies then not sharing this information with FBI and the domestic law enforcement agencies, which is going away, but with the administration's own admission. So that could change, but at least in terms of litigation, the courts have historically been so deferential that we don't even get to the point of a federal judge investigating, well, what tools or services did you use to gather foreign intelligence? I don't know, Kia, if is that an issue that ACLU has litigated recently, just use of private actors? I know a lot of companies are also using, I mean, it's become more common to yeah, for a lot of big tech companies to hire AI services to scan, to enforce sanction regimes and activities that might raise red flags with like foreign terrorist designations and all those things. So it's the private party conduct is very interesting.
Yeah, I mean, so I would say a few things. One, when it comes to AI surveillance, it's not a topic that we in the national security, it's not a topic that we know a lot about. As you won't be surprised, the government doesn't like to share what it's doing in this space, and one of the biggest things we're always pushing for is just more transparency because we don't really understand what is going on in that space. I think a couple things. I think social media monitoring, they're definitely using AI to do that. I think we'd argue things like facial recognition, things like using ALPRs, automatic license plate readers, are forms of using artificial intelligence. And one of the other things is that couple of things. I think that one, and this was the issue, one of the things that was an issue between Anthropic and the Department of Defense is even if you're not using the AI to actually surveil people, they are using the AI to kind of pull together these huge data sets and basically create profiles on Americans in a way that was like never possible before, and which is like pretty concerning. So there's that piece of it. But there's also like with programs like the Section 702 of the Foreign Intelligence Surveillance Act, um, there are concerns that they could be using AI to search those databases, which includes the information of Americans. And because they're using AI, they're basically saying, oh, we're not like again, we don't know. It's just speculation, but in different ways, it could be pulling on Americans' private communications in ways that we don't know because the AI is kind of just scraping all the data.
And kind of on that note, I'm curious, one of you had mentioned that, excuse me, that flagging, that scrubbing your social media too much might raise a red flag. Many people aren't on social media. Their use of social media fluctuates over the years, over months. What is the department's official position on travelers who claim they don't use social media? Are they being flagged for identity concealment? Is that blocking their applications?
Yeah, I'll let you handle this one if you know. This is actually not something
No, I mean
I know the answer to.
anecdotally, I'm never I think there's some um deliberately there is some lack of detail on how the agencies are actually handling reviewing social media. There's no reason for them to disclose the details. Um, uh, Anecdotally, I would not be surprised that if you were submitting an immigration application and you're completely leaving blank and claiming that you don't have any social media accounts and they can review your nationality, that they would not be suspicious. But I'm assuming we will find out more. I think this is an area of law where a lot of these issues are potentially going to be better handled through congressional investigations than litigation at the courts. Congress could probably, I'm wondering if he knows if there's going to be movement or not to pay more scrutiny on the Hill. But it's much easier to dig up this information about the details of enforcement first through congressional investigation and then use that as an avenue to litigate against the federal government, which makes, I guess, the past November, if there's a change on the Hill, that's going to be interesting. It might answer some of these questions. Kia, I don't know. Is there an incentive from Congress to to look into the details
Oh yeah,
of
I would say that they're on the Democratic side. There's a significant interest in these issues. I think we've seen a lot of Democrats on both the Senate and the House who have been asking questions of the administration, and I think that the administration has not been the most forthcoming, unsurprisingly. What may change is in November if the Democrats take the House. they will be able to, issue subpoenas and investigate a lot of this stuff. And I think it's very much my expectation that if that happens, you will see a robust oversight effort on these questions.
Yeah, I'm sure. I mean, part of this is that the administration's relationship with the big tech companies is a big issue here too. It's, I mean, at least in terms of sanction enforcement or enforcement of, placement on a list of foreign adversaries or whatever, the big tech companies have shown themselves to be very sensitive in cooperating with whatever the administration's priorities are. As soon as there's an inkling of a user being investigated for those issues, the big tech companies don't really need to be pushed too much by the administration to suspend accounts or turn over data. Mileage varies from company to company. But in terms of, again, veracity of an applicant before the federal agencies, I think people do need to take into account that they shouldn't be surprised if the federal government has other avenues of finding out what your online activities are aside from just asking you.
The
Yeah, and I think, oh, go ahead, Kim.
The corollary of that is if you saw once you saw that they came down on Anthropic, how quickly ChatGPT jumped in there and was like, "Oh, we'll do all the things that you want." And I think Anthropic is. I would not say that our position is the same as Anthropic's because it's a little more nuanced than that. But I will say they should be commended for actually standing up to the administration when so many others weren't willing to do so.
And I think, Kia R, something that you had mentioned was the fact that there's so much that we don't know about how they're making their decisions, what criteria they're using. They've instructed and they've released executive orders and press releases to the effect that they're screening for anything that is anti-American or anti-capitalist or anti-Christian, but that's it's pretty broad, and there is no formal legal definition for any of those terms, or I don't even know if there's a formal definition for those terms as far as the executive is concerned. So obviously you raise the issue of potential political bias, but do we have any sense of what might actually constitute being anti-American or anti-Christian? I know Kia H mentioned being vocal in Palestine. Are there other kind of like hot button issues that we think the AI is screening for?
Not liking Donald Trump. I mean, just to be completely frank, like I'm sure that if you have said negative things about Donald Trump, it's something that they're looking for, which should not be anti-Americanism, but under the current administration, maybe it is.
Yeah, I mean, I've seen memes of things like even having memed pictures of JD Vance on your phone might be a basis to have your visa application denied or your entry denied. So yeah, I think it's very, to put it not very legally, it's very squishy and not precise.
Definitely. And I mean, challenging on Nikki, like you mentioned, typically the main avenue of litigating these issues would be to just challenge the guidance as vague. A lot of the executive orders from the new administration have been subject to that kind of legal challenge. Even, it's similar to regulation of DEIA activity. The administration's never formally defined what DEIA is. So there's active lawsuits just on that issue. We'll have to see how it plays out. But it always puts potential plaintiffs at a disadvantage in court because you're claiming that your understanding is that the guidance is being enforced one way, and usually DOJ's position when they show up to court is no, that's not what we're doing. That the plaintiff needs to prove that that's actually how the guidance is being applied. And before the courts, they always say, well, we wrote the guidance this way, but it has an embedded presumption that we're going to enforce it in line with constitutional rights. We're not going to be reviewing people's social media posts for their content. Again, I think if there is going to be a strong challenge and pushback, it's going to be through first some kind of information gathering through FOIA or through congressional investigation to figure out the details of how the guidances are being enforced, and then hopefully challenging them.
And my last question kind of on this point is particularly with regard to, visa application. Most people if, I'm guessing if you're applying for a visa, there's a good chance that your social media is not primarily in English. And we, know that automatic translation is not always the most accurate. So is there any kind of, appeals process, or do we know anything about how DHS or consular offices are, preventing errors or, second look at things? How are they viewing social media posts that aren't written in English? Do we know? We may not know.
I mean, I think the biggest point is again, these tools make mistakes, right? I think with a lot of these technologies, they're treated as if they're foolproof, and very much they make mistake, and then decisions are made based off those mistakes. And we know that, and that's true in like a variety of like these sorts of technologies.
Okay. Well, to kind of switch gears to the kind of the final topic that we have planned, something that's come up in passing during this conversation is FTO, or foreign terrorist organization designations. Could one of you walk us through what an FTO designation means, just at a very basic level?
Yeah, so it means basically three things. There are three real impacts. One, anyone who provides material support to a foreign terrorist designation can be prosecuted under criminal law. Two, anyone who's a member of a foreign terrorist organization cannot get admitted to the United States. And three, there's a number of like kind of asset seizures and financial penalties is kind of the main three impacts. I think the important thing to note is it doesn't unlock any sort of like war powers. It doesn't unlock any, and it doesn't act as like an AUMF in any way, and it doesn't also unlock any sort of surveillance authority.
Okay. Yeah, Ar, do you have anything to add on that front?
Just that I mean the last year or so the news on that front has been the states trying to get more involved in this, and I think Akia is right. A lot of states see this as more of a this they might see their role as a mini intelligence agency for the federal government. They're trying to come up with their own designations and use it to effectively force certain kind of reporting on different organizations or associations whose work might involve collaborating with foreign entities. It's put a lot of entities that we would historically believe to be protected by the First Amendment at jeopardy: law firms, NGOs, interest groups, for their connections and collaborations with entities who operate outside, who have political affiliations that the administration doesn't view favorably. A lot of Middle Eastern organizations, a lot of Chinese organizations. Those lawsuits are also making their ways through the courts, and we'll have to see if the courts stop in to effectively stop the states from getting involved in this area of regulation by either, there's this concept of preemption of federal law, which is some aspects of our political governors are supposed to be left to the federal government. Foreign policy historically has been one of them, which is let the federal government speak with one voice. We want uniformity amongst the states. So that's going to be a huge area of litigation in the next year of the federal courts having to decide whether or not the states can have their own designations for foreign adversaries or foreign terrorist organizations, and then go after citizens and non-citizens' professional conduct if they touch on collaborations with the listed entities.
So the other, okay.
No, go ahead, please.
No, the thing I got at the state level is one of the things there's been a lot of reporting on is that it's really being driven by anti-Muslim sentiment. So in states like Texas and states like Florida, now that Trump is president, Republican primary voters don't care about the border because the border's been solved. And so they're the number one thing that Republican primary voters care about is the number of Muslims in America. And so I think a lot of these laws, especially in Texas and Florida, are driven because they're very much directed at organizations like CARE, and they're driven by kind of the sentiment of Republican primary voters, more or less. And the second thing I was gonna add, and going back to the federal designation, the other thing to note about it is it's completely something that's done by the executive branch. Congress doesn't vote on whether someone's an FTO. Congress, if they wanted to, could pass a law and say someone's not an FTO. The Congress could also pass a law and say someone is an FTO. I think you've seen there have been efforts in Congress to try to declare Muslim Brotherhood an FTO, for instance, which hasn't passed, which hasn't become law yet, but you see those kinds of efforts all the time.
And how do you think, just with this administration's, for lack of a better word, creative use of various enforcement schemes, especially in the nonprofit space, we've seen them threaten to, weaponize the IRS, but haven't actually, done that. That's kind of, they haven't done that. How are they using these various schemes, FTO, using the IRS to create a chilling effect among kind of nonprofits?
I mean, I think the threats themselves create a chilling effect, right? I mean, and there's within the tax code, there's a provision called 501p, which links back to the IRS code and essentially is a way you can lose your nonprofit status. And I think there at different points there have been concerns that the Trump administration is going to use that. There have been threats to do that. It hasn't happened yet. There's another there's a NSPM 7, which is like another part of that. We saw recently there was an announcement the FBI and IRS formed a task force to go after nonprofits. So I mean, like it's definitely something that's like a real threat, and I think just that threat is chilling to people. There is a very good statutory provision in the tax code that basically prevents targeting, like the political appointees from targeting specific organizations. It's been on the books since in the aftermath of Richard Nixon, that is a pretty good um, provision, and I think has been helpful in trying to deter some of this. Doesn't mean they won't try, but it's been helpful to deter.
And I know you mentioned that Congress, like this is something that's done by the executive branch, like the FTO designation, but I think the attention on nonprofits, whether it's from the IRS, like, from the IRS Ways and Means kind of side of things or the national security side of things, we have seen this Republican Congress use their investigative tools to look into nonprofits more. So is that an area where we're seeing kind of harmony between state attorney generals, Congress, and the executive branch?
I mean, very much so, and it's particularly in the aftermath of October 7th, right? There was a huge effort to take a bunch of U.S. nonprofits, particularly progressive groups, and say that they were providing material support to Hamas. And I think one of the important things about material support is um, independent advocacy does not count as material support. You need to have basically direct coordination or at the direction of an FTO. And I think that a lot of members of Congress don't really understand how that works. But I mean, there were a lot of things that were referred to as material support that wouldn't actually qualify as material support under the law. And there was a bill that they tried to push that didn't get through. That would have given the Treasury Secretary pretty broad authority to kind of unilaterally declare anyone a supporter of terrorism and strip them their nonprofit status before they could actually go to court. And that didn't become law, but that was kind of an effort that was kind of under going on in Congress. And since then, we've seen a ton of investigations from the Republicans in Congress, but primarily into progressive groups, and a lot of it being linked to October 7th and whatnot, but not solely that.
I think relatedly, there's been a lot of attention on progressive groups, and they're trying to use like the domestic terrorism angle, with protests against ICE, everything that was going on in Minnesota. They've kind of used the domestic terrorism angle. Is there a similar kind of framework, the way that there's a very clear FTO framework? Does that exist for domestic terrorism?
It doesn't. Right? I think this important thing is that they've said they want to create a domestic terrorism list. We haven't seen that list. We don't know who's on it, but there is no legal effect of being on such a list because there's no domestic terrorism framework that's been created by Congress. That doesn't mean that won't have a chilling effect, and that won't if people find out you're on the domestic terrorism list, they don't want to do business with you or something like that. But there's no being named. If Trump comes out with a domestic terrorism list and you're on it, there's no legal effect of that because there's no such thing in statute.
Yeah, or anything from you? I think I jumped in there a few times even before you could
No, I
speak.
agree. I agree. I mean, the domestic terrorism list is going to be a challenge to establish anything like that. I mean, it's at least hopefully the federal courts will be standing in the way of that. I mean, a lot of, like I mentioned, historically, a lot of intelligence gathering in the U.S. has been given a green light by the high court and by the federal courts under the assumption that the federal government is going to use it for foreign policy purposes effectively. Taking all those tools and uh, taking the court's historical permission and then trying to use it as a back way to do law enforcement domestically, it's gonna have a that's gonna be a tough sell for the courts.
Wonderful. Well, I think that's it from everything that I plan to discuss. Anyone online, if there are any more questions, feel free to drop them in the chat. I don't see anything, but I'll give it another minute or so to see if anybody has any additional questions for our panelists. Or if it's easier, you can raise your hand, whatever's easiest. I'll give it another minute or so. Kamran or Cameron says, thank you for answering my questions. Thank you for asking your questions. They were excellent and very thought-provoking. Okay, well, not seeing any. Oh, okay. Yeah, I don't think I see any questions. I think that you guys covered everything. Thank you so much. I think, this panel was just one example of seeing, the wonderful subject matter experts that we have in our community, just such thoughtful and, deep discussion. I really appreciate both Kia's time and attention and expertise, and, just feel very grateful to have people like this in our community who are so engaged on these really important, pressing, and scary issues, if I can say so myself. But thank you to everyone else for joining this afternoon and early evening. Really grateful. I wanted to go ahead and plug our next webinar. We haven't publicized it yet, but we'll be doing an environmental law webinar with another Iranian American subject matter expert. That'll be the week in honor of Earth Day, about a month from now, in late April, and hope to see everyone there. We'll be providing advertising for that on our social media and registration link and stuff. But thank you all so much for joining, and most of all, thank you to Kia for your expertise and volunteering your time. I truly appreciate it, and it's been such a pleasure discussing these issues with you.
Thank you, Nikki.
All right, bye everyone. Have a great rest of your evening. Thank you. Merci.